Yes, hello. That's Stefan Höfer from Deutsche Börse. Welcome to the first Capital Market Partner webinar in 2018. Theme of this webinar is the extraterritorial reach of the US securities laws. The webinar will be held in English language due to our international reference of Morgan Lewis. I'm glad to introduce Carter Broad, partner in London, Finbar D. Murphy, partner in New York, and Dr. Thorsten Schwarze, partner in Frankfurt. Gentlemen, the floor is yours.
Hello, my name is Thorsten Schwarze. I'm a partner in the Frankfurt office of Morgan Lewis. I just want to very briefly introduce the firm to you and today's webinar. Morgan Lewis was founded in 1873 in Philadelphia. It today comprises more than 2,000 lawyers worldwide. 200 lawyers focus on securities transactions. We advise on all types of capital markets transactions. We also have a Frankfurt office, which is basically a hub to Morgan Lewis global network and platform. So if there are any issues, we will direct you to the right expert. Today's topic focuses on the extraterritorial reach of the US securities laws. There are certainly other US laws which have an extraterritorial scope, like the Dodd-Frank Act or FATCA or the sanction laws. To the extent we cannot cover these topics in today's webinar, but you have questions on them, please let us know and we are happy to help you further. That being said, I will now hand over to my partner, Carter Broad from London, to talk about Regulation S. Carter?
Thanks, Torsten, and good afternoon, everyone. As Torsten mentioned, this presentation is solely focused on offerings and sales of securities outside of the United States. And the goal of this webinar is to give you a basic understanding of what you need to do in structuring or executing your transactions to avoid inadvertently becoming subject to the U.S. securities laws when you do a transaction that is done in Germany or elsewhere outside of the United States when you don't have any intention of involving the United States in that transaction, such as not selling to U.S. investors in particular. Now, there are two main ways that the U.S. securities laws could impact a transaction that is done solely in Germany or otherwise entirely outside of the United States. The first way is with regard to the exemption from the registration requirement with the SEC. If you don't have a valid exemption or a safe harbor for your transaction, your transaction could be required to be registered with the US SEC. So it's important to have that. And secondly, even if you meet the requirements of a particular exemption or a particular safe harbor, and therefore you do not have to register with the SEC, if you do certain things in your transaction, you could become subject to US jurisdiction and therefore incur civil, administrative, or even criminal liability in relation to that transaction. So I'm going to cover the first part of this, which is ensuring that you have an exemption from SEC registration, and then my partner Finn in our New York office is going to cover the second part with regard to jurisdiction and liability. Now, the key exemption from the U.S. securities law registration requirements with the SEC for transactions done outside of the United States is Regulation S. And Regulation S is technically what is called a safe harbor for U.S. securities law purposes. Before explaining what Regulation S is, I should first cite the most fundamental rule in the U.S. securities laws, which is Section 5 of the U.S. Securities Act. And that says that any offering and sale of a security must be registered with the SEC unless there's an available exemption. Now that you may have noticed from my statement of the rule, it doesn't say only in the United States. So in theory, this rule with regard to SEC registration would apply to a German issuer offering securities only to German investors. That may seem crazy, but the U.S. securities laws are far-reaching, and this has become ever more so in today's world with the globalization and interconnectivity that we have in the world. In 1990, the SEC introduced Regulation S in order to clarify the extraterritorial application of Section 5, the registration requirement. And Regulation S is actually a series of rules under the Securities Act. And those rules provide that you don't have to register your transaction with the SEC if you meet the requirements of the applicable rules. Now, it's admittedly circular in that if you want to avoid U.S. law in your transaction, effectively you need to apply U.S. law, Regulation S, and in some cases you have to actually involve U.S. lawyers. And some people may refer to this as being the arrogance of the U.S. securities laws, where there are laws applied to transactions that don't have anything to do with the U.S., but this is just the way it is in terms of particularly the interconnectivity and globalization of the world today. Before getting into the actual rules of Regulation S, I should note that the term Regulation S, in addition to referring to the set of rules under the Securities Act, has a looser meaning in market practice when it's applied to a particular transaction. For example, if you say that we're doing a Reg S offering, a Regulation S offering, that means in your offering you're not selling to any investors in the United States. You can also have a combined Regulation S transaction with another type of transaction, like a transaction that involves a sale into the United States under an exemption, such as Rule 144A. So you will have an offering that has a Reg S tranche and a Rule 144A tranche. And that is a structure that most major global offerings, including many done by German issuers, have today. So now to discuss the rules in Regulation S themselves. What do you need to do to comply with the actual safe harbor? Now, there are actually two safe harbors in Regulation S. One is for issuers, so that's really like the offering exemption, and the other is for resale, so secondary market transactions when you're reselling securities as opposed to them being sold by the issuer in an offering. Now, under the Rule 903 issuer exemption, or the issuer safe harbor, there are two basic conditions. First of all, transaction must be an offshore transaction. Secondly, there must be no directed selling efforts into the United States in that transaction. The offshore transactions part is fairly obvious. The transaction needs to be executed outside of the United States. But the directed selling efforts requirement is less straightforward, and basically it is founded on the principle that Regulation S is focused on the risk that the securities that are sold outside of the United States will flow back into the United States. And therefore, by having directed selling efforts in the United States, you're viewed as conditioning the market potentially for your securities, and therefore making it more likely that the securities will flow back into the United States. So if you have directed selling efforts in your offering in the United States, you shouldn't benefit from the safe harbor. Now, these terms, offshore transactions and directed selling efforts, have complex definitions, but I think that you'll generally understand the basic idea, which is that the transaction must be outside of the United States and there must be no conditioning of the U.S. market in the transaction. So I mentioned that there are only those two basic requirements, offshore transaction and no directed selling efforts. So it should be easy to comply with Regulation S, correct? Well, not so fast. As I mentioned, Regulation S is concerned about the risk of flowback into the United States. So there are additional requirements that are imposed for certain types of issuers and also certain types of transactions. And these additional requirements are referred to often as the anti-flowback restrictions. And the different types of restrictions that apply are calibrated to the level of risk that is involved in the particular transaction, that there'll be flowback of those securities into the United States. The first category of an issuer is Category 1. If you fall into Category 1, there are no additional requirements, so it's just offshore transaction and no directed selling efforts. For a German issuer, it's generally going to be, for most German issuers, they're going to fall into Category 1. One of the requirements for Category 1 is that there be no substantial U.S. market interest, or otherwise referred to as SUSME, in the securities being offered. And for most German issuers, they're going to be Category 1, unless they have a listing in the United States. The definition of SUSME is quite complicated, but it really depends on the amount of your securities that are traded in the United States relative to other markets outside of the United States. So if the primary market for your securities is the United States, then you are unlikely to be in Category 1. So most German issuers, again, just to emphasize, are going to be Category 1, and they're only going to have to meet those two requirements. However, I'm going to run through Category 2 and Category 3 just to give you an idea and a flavor of how technical these rules are. Category 2 is for medium risk offerings, a medium risk that there'll be flow back into the United States. First of all, if you don't qualify for Category 1, then you need to look to Category 2. An example of a Category 2 a German issuer would be a German company that has equity or debt listed in the United States. If you're in Category 2, in addition to offshore transaction and no directed selling efforts, you have to apply a distribution compliance period onto your transaction, which is a 40-day period during which securities can't flow back into the United States. In addition, you cannot sell to U.S. persons outside of the United States. With regard to Category 3, and the next slide has a detailed description of the definition of U.S. person. You can see that this is quite complicated. It's not straightforward. It's a very technical definition, but that would apply if you have a Category 2 transaction. With regard to a Category 3 transaction, which is a transaction which does not qualify for Category 1 or Category 2, you have some additional requirements. Category 3 is perceived to be the highest risk that the securities sold offshore will flow back into the United States. So this has the highest amount of restrictions on the transaction. And generally, a typical Category 3 issuer is going to be a U.S. company that's doing an offering outside of the United States under Regulation S. You can understand why they would be perceived to have the biggest risk of flow back into the United States because they're a U.S. company and they're more likely to be known by U.S. investors. And then finally, just to touch on the resale part of Regulation S, the two most basic requirements, and this is Rule 904, are the same as in the Rule 903 issuer safe harbor. Those are offshore transaction and no directed selling efforts. And I should point out that offshore transaction for this purpose includes trading on the trading floor of a recognized non-U.S. stock exchange, which includes the Frankfurt Stock Exchange. There are some additional requirements that apply to resales under Regulation S. But they apply to particular types of persons selling the securities in the resale, such as affiliates of the issuer, and also, again, certain other types of issuers. So that's in a whirlwind nutshell, a summary of Regulation S. Transactions offered and sold outside of the United States to avoid the requirement to register your transaction with the SEC. And now I'm going to turn over to Finn Murphy from our New York office, who's going to explain that just because you have a valid safe harbor and you don't need to register with the SEC, doesn't mean that you're off the hook. You could still trip up and fall under the U.S. Jurisdiction and therefore become subject to certain U.S. securities laws. Finn?
Thanks a lot, Carter. As Carter mentioned, I'm going to speak about the application of the U.S. federal securities laws in terms of liability, potential liability to issuers and sellers of securities. And as Carter mentioned, even if an exemption from U.S. registration is available, or for a new transaction, or in relation to secondary trading in a security that's been issued for some time, where you're not really looking to structure an exemption, there is potential liability under the U.S. securities laws in situations where you might not expect it to apply. And there's been a change in the recent past in terms of that application. Historically, the U.S. courts applied what was called a conduct or effects test. And essentially that looked at whether there was U.S.-based conduct that had impact on non-U.S. shareholders or non-U.S. conduct that had impact on U.S. investors. And what that essentially meant was, if a company had a U.S. listing, regardless of where any particular trade or transaction occurred in the world, and regardless of who the investor was, there's a good chance the U.S. securities laws would apply, just given their U.S. listing and U.S. reporting requirements, whether that's a foreign company or non-U.S. company or U.S. company. Similarly, even if a company was listed solely in Germany, if a U.S. investor bought securities either in a new transaction, a new issuance, or just trading on a German exchange with the Börse, there very likely could be U.S. securities law liability because of the impact on the U.S. investor. Now, in 2010, in a case called Morrison versus National Australia Bank, a dramatically different test was sort of adopted by the U.S. Supreme Court. And in that case, it essentially held that the U.S. securities laws in civil cases only apply if the security is listed on a U.S. exchange and the transactions occurring on that U.S. exchange, or if the transaction occurred in the United States. And so this substantially limited the extraterritorial scope of the U.S. anti-fraud laws in civil cases. It was a big change, and this has been the law since 2010, but it's still, frankly, being worked out. Its various permutations in terms of court cases. But so again, today, the anti-fraud liability only occurs if the transaction is in a security listed on the U.S. stock exchange, or the transaction occurs in the U.S. Now, listed on a U.S. stock exchange is pretty clear. That's if the trade is essentially executed on a U.S. exchange. Then, as you might expect, the U.S. Anti-fraud rules would apply, wherever the company may be incorporated, wherever the investor may be. The fact that the transaction is executed through a U.S. exchange brings the U.S. law into application. Now, in the United States is the other way that the U.S. securities laws could apply. That's a little trickier and has been the subject of various cases since then. We've set forth on the slides, some of the factors to determine whether there's a U.S. transaction, a transaction occurring in the U.S. that therefore attracts potential liability. The courts will look at where the contract was formed, where the purchase order was placed, where title was passed, where money was exchanged, and other potential factors. They're sort of looking at where the irrevocable liability occurs between the buyer and the seller. So in effect, what that means is if you're doing a transaction on a non-U.S. exchange, if you're executing the exchange, the transaction there, it's very unlikely that U.S. securities liability would apply. Even if it's a U.S. investor or a U.S. company, as long as the transaction is occurring on a non-U.S. exchange or otherwise outside the U.S., you should not have U.S. anti-fraud liability for that transaction. And that's a big change from the regime that was in place before the Morrison case in 2010. Some of the more, let's say, complex financial instruments or situations that are less clear cut. One is ADRs, American Depository Receipts. Of course, those are traded in the U.S., but represent securities of non-U.S. companies that tend to be listed, on an exchange in Germany or elsewhere outside the U.S. In those cases, there's been some. If those ADRs are listed in the U.S., chances are the U.S. securities laws will apply. But there has been some cases holding the opposite, saying, look, although the ADRs are listed here in the U.S., really you're trading the underlying security. It's really a German security. We shouldn't bring the U.S. securities laws into play there and let the German laws apply. If it's OTC traded, as many ADRs are, especially unsponsored ADRs, there's a good chance that the U.S. security, anti-fraud liability will not apply. Derivatives, another kind of complex case. There's a well-known case in this area, the Börse case, where there was a swap or derivative created in New York with New York law governing, with U.S. buyers, but really the reference security, the value, was dictated by the Porsche securities listed in Germany, and the U.S. cases said, look, just because someone created a derivative that referred back to a German security doesn't mean we should bring kind of the German trading and German disclosure regime into question in the U.S. courts. And so that's not going to be, even that derivative, that New York law governed derivative traded in New York is not going to subject the buyers and sellers of that to U.S. securities law liability. Cross listings. This may seem commonsensical, but it is a good clarification because it was not always the case before Morrison. And there has been case stating that, look, if you have a dual listing, you're listed in Germany, you're also listed in New York. If the trade happens, and therefore you're reporting to the SEC, you're an SEC reporting company. If the trade happens on the Frankfurt Exchange, then that trade is not subject to the U.S. Anti-fraud laws as a civil matter. So that's a helpful clarification. Flipping to the next slide, I guess a word of caution, which is that there still are additional bases of potential liability. We've been talking about civil cases. In other words, a private cause of action, a case brought by, an investor, a private investor, not brought by the regulators. And we also haven't been talking about criminal liability. Generally not at issue, but can be. In terms of criminal liability, in 2013, the Second Circuit Court of Appeals here in the United States held that essentially that to be held for criminal securities fraud, you should look to essentially the same test as in a civil fraud case. In other words, this Morrison test, is the transaction occurring on a U.S. exchange or is the transaction occurring in the United States? So they essentially are bringing into harmony the criminal and civil regimes for anti-fraud liability here in the U.S. Regulatory matters, the SEC and the Department of Justice still have jurisdiction under the Dodd-Frank Act, which was passed by the U.S. Congress in 2011, to regulate conduct within the U.S. That constitutes significant steps in furtherance of a securities law violation, or conduct occurring outside the U.S. that has foreseeable substantial effect within the U.S. So on the regulatory front, there's still a broader extraterritoriality theme to it. So that's, again, as I note here, there's still some uncertainty in that area in terms of how aggressive that's going to be applied, given the Supreme Court's ruling in the civil space. So that's just a quick summary of the liability regimes that they can apply, irrespective of whether you have a transaction that's exempt from the registration requirements of the U.S. securities laws, and again, even in secondary trading where you're not really focused on structuring the transaction.
Yes, thanks a lot. Greetings to New York. Now we have the first question from me, the Hein, that you please use your chat board to give us the questions, and the reference will be glad to answer them. The first question is, are non-US investors entitled to join class action lawsuits brought in the United States against non-US companies?
Jim, do you want to answer that one?
Sure, I'll take that. The answer to that is probably not. There's some uncertainty around that, but the basis for forming a class action in the United States is that is the superior way to dispense with that issue. So in order to bring a class action lawsuit in the United States, you have to essentially get court approval that a class action is the appropriate superior way to dispense with that issue. And what that focuses on, among other things, is the thinking behind that is to let the plaintiff and the defendant address this issue all at once in one go, and not have to keep relitigating it with different plaintiffs again and again and again in kind of a serial fashion. And the issue for a non-U.S. investor joining that kind of class action, even if there's potential liability to the plaintiff, to that non-U.S. investor, is a matter of judgment recognition in that non-U.S. country. So in other words, if there was a question as to whether the German courts would recognize that judgment of the U.S. case in the class action as binding in Germany, and also in being preclusive, meaning that further plaintiffs could not emerge and bring a similar case in Germany. Absent that preclusiveness, the U.S. court probably will not let a non-U.S. shareholder into the class action. And in many jurisdictions outside the United States, there's a lot of question around whether that home country court would give preclusive effect to the U.S. judgment.
Next question. If a company issues a press release in Germany that discusses a security offering and the press release is picked up by investors in the US, will this constitute directed selling efforts in the US, such that I would no longer satisfy Reg S?
Okay, I'll take that one because it relates to Reg S. It's a good question, and obviously this goes to one of the two main requirements for any Regulation S transaction, as I mentioned, and the part of it is one on directed selling efforts. And because of the interconnectivity of the world today, and also the internet, it's certainly conceivable that if a German company issues a press release in the German market, whether it be German language or in English or another language, that will flow into the U.S., get picked up by news wires, and become accessible to U.S. investors. And it's a legitimate question to ask. If that happens, have we engaged in directed selling efforts in the U.S. such that we no longer benefit from the Regulation S safe harbor? The answer to that is, fortunately, it will not constitute directed selling efforts so long as that offshore press activity is done in a particular way. And in particular, the SEC has promulgated a set of rules, which are called Rule 135, and there are a couple of subparts to that, which deal with offshore press activities, both written and oral, so press conferences as well as issuance of written press activities, if those press activities take place outside of the United States. And the basic rules say that as long as you comply with the requirements of these rules, when you do these offshore press activities outside the United States, they will not constitute directed selling efforts. And there are different types of requirements depending on different facts and circumstances, but in general, the requirements are that for written press materials, they have a certain U.S. legend on them that says that the securities, among other things, will not be registered in the United States, and are being offered pursuant to an exemption from the SEC registration requirements. And also there are certain content requirements in terms of what those written press release materials or oral press activities that are done outside of the United States can say.
Why do many prospectuses provide that only non-US persons are entitled to purchase the securities being offered under Reg S, when there is no prohibition on purchases by US persons located outside in the US for Category 1 offerings?
Okay, I'll answer that one as well. This is a common question that we get from market participants, issuers, even investment banks, and more sophisticated market participants. Because if you look at a lot of prospectuses by German issuers, for example, which don't have listings in the United States, and this could be debt prospectuses or equity prospectuses, you will often see a legend on them that refers to Regulation S, and it says that the securities cannot be offered either in the United States or to U.S. persons. And if you recall, during my part of the presentation where I discussed Category 1, which is what is applicable to these issuers, there is no requirement in that relates to U.S. persons. It is only offshore transaction and no directed selling efforts. So the question is, well, why did or have people made a mistake by putting that in there? And the answer is that there's a feature of market practice that has developed, which is referred to sometimes as prudential Category 2 restrictions, whereby even though the issuer is a Category 1 issuer and there's no requirement to exclude U.S. persons from participating, the deal teams doing the transactions will voluntarily apply certain restrictions from Category 2, including the prohibition on participation by U.S. persons. And it's just really an extra belt and braces feature that is designed to bolster your Regulation S safe harbor. So it's not actually required, but it is something that is commonly applied in market practice.
Okay, so thanks a lot to all three referents, to Finbar in New York, to Carter and Thorsten here in Frankfurt. That was Morgan Lewis with the extraterritorial reach of the US securities laws. We will send you the stream of the webinar and, of course, the slides tomorrow. Wish you a good day. Bye.